so hey. My name is Lena Betko. I'm an attorney with Washoe Legal Services. I'm currently with the Elder Law Unit over in the Consumer Protection and Landlord-Tenant Division of Washoe Legal Services. But prior to doing that, I worked 2 years with volunteer attorneys for rural Nevadans and literally did nothing but family law under the auspice of domestic violence, but lots of experience with custody and divorce, guardianship, all that great stuff. So I only have an hour today, so I'm going to try and focus on just the main bullet points of child custody. So what are the factors the court's going to look at, differences in different types of custody, and the biggie, which is the best interest of the child. And I can tell everyone, if you ever have questions about what Nevada law on child custody or divorce is, you should look up Nevada Revised Statute 125. It's Nevada Revised Statute, or NRS 125. It's labeled A, B, and C. And for most custody and divorce purposes, NRS 125C is where you're going to find pretty much all your answers on everything. 125B covers child support. So let's get into this. So, when you're looking to do child custody of any type, whether it be under the auspice of a divorce or you were never married, the first thing you have to ask is, does the court have jurisdiction? Now, what does that mean? So a court can only enter an order on physical custody, that means who gets to have the child when and where, if that state is the child's home state. What does home state mean? Home state means wherever the child has been living with a parent or a person acting as a parent, so sometimes like a grandparent, for the last 6 consecutive months. Temporary absences from the state don't count, so if you've been living in Nevada for 6 months but went to California for 2 weeks to Yosemite on vacation, that doesn't count. As far as they're concerned, 6 months in Nevada. If the kid's under 6 months of age, then they're going to look at the state where the child's lived from birth, including any temporary absences, with the parent or the person acting as a parent. So if you have a 4-month-old, where has that child been living primarily? And if it's Nevada, then Nevada will be that child's home state. So what if there's a dispute over the home state? I'm not going to go into a bunch of detail on this other than to say it does come up, especially between California and Nevada. If there's a dispute, you're going to have what's called a Uniform Child Custody Jurisdiction Enforcement Act hearing, or as I've labeled it up there, UCCJEA. You have to prove to the court essentially in whatever state that you're trying to file for custody that that court has the greatest interest in granting you the order. So I'll kind of go through this and then give you an example because I feel like the examples are a lot better ways of illustrating it, and I've had this come up a couple times in practice. I will say though, if it's an issue where you know it's going to come up because you're filing for divorce and you're trying to get custody but you haven't been in the state a total of 6 months, then you should put that in your initial petition for divorce. Or if it's just custody, that you're going to have a hearing for this. It's always good to let the court know. You'll also have to do a separate motion. But I always tell people that if you know that's going to be an issue, tell them right in the get-go in your petition. So factors the court will consider at that hearing are going to be, per example, safety of the child. So did you flee to Nevada from California because you were a victim of domestic violence? Resources available or set up for the child in the state where you're seeking custody. So if you haven't been here 6 months but the child has maybe special needs and you have doctors set up here, teachers set up here, other things for the child to help them in their needs set up here that they don't have available in the other state. I'm just using California as my example. Then that's a factor to be considered. And then any other compelling interest of the forum state, which really could be anything. So I said I'd give an example. So example, when I was in volunteer attorneys, I had a client and she was a victim of domestic violence in California. Without going into too much detail, the guy beat her up pretty bad. So with the help of advocates in California, she and her 10-year-old daughter fled to Reno. They hadn't been in Reno for 6 months before she was hearing through the grapevine that dad was trying to file for divorce and ask for custody of the kid and all kinds of great stuff. And even though they tell you it doesn't really matter, the type of case you have, I can kind of tell you from experience, it seems like it's better if you're the plaintiff in a divorce because you kind of get the first shot out there. So she was kind of freaking out about that. So I ended up filing for the divorce even though I knew that Nevada wasn't going to have jurisdiction over the child just flat out because I hadn't been 6 months. And we requested this hearing in the petition and I filed the motion, citing the fact that it was well documented that she'd been beaten up pretty badly. There were medical records supporting that. There was court documents from California. She had advocates write statements that they'd helped her come here for safety purposes. that it would not be safe to handle the divorce or child custody issues in California because of safety risks to not only my client, but the child. The abuse secured in front of the child, fun fact. And then she'd been here for a while, like not quite 6 months, but the child was in school, the child was in tap dancing lessons, the child had, organizations and friends here. And they were basically, our argument was, Nevada should be the one who does the custody action in this divorce because California is really not safe, and honestly, she's been here for so long, they have the greater interest in doing it. And at the end of the day, the California court agreed and said, looking at this domestic violence history, how long she's been there, Dad hadn't really tried to reach out or do anything in the meantime. I think there was a protection order in place too out of California. And so California seceded its interest in the custody action and gave the court in Nevada permission to go ahead and handle everything. So that's an example where home state can come up. I also feel like I should be remiss if I didn't mention that if you and your partner were living in Winnemucca for 2 years and had a child, and then you separate and you move to Reno, you don't get to file for child custody in Reno, you have to file for child custody in Winnemucca. Because even though it's the same state, you also have to look at the jurisdiction for where your child's living. And Winnemucca, I believe, is the 6th JD, and we're in the 2nd here in Reno. So the 6th JD is going to be the one who's going to want to handle that, because if your child's been living there, that's the place where they're going to have all the evidence and information about the child, like schooling, doctors, everything else you could mention. And it's going to be a lot easier for Winnemucca to get that information than up here in Reno. Plus, theoretically, if the child and the mother, who would be the defendant, are living in Winnemucca, that's where you want to file anyway. So that was a lot of information. Any questions on that part? All right. So, as I've been kind of mentioning, there's different actions for custody. There's custody under a divorce. There's custody when you were never married. What's the difference? There used to be a lot more differences. I can tell you that. There used to be a presumption if the parents weren't married that custody lied with mom. That's no longer the case. Whether you were married or not married, it's presumed that joint custody is what's the best interest of the child and what should happen if the court hasn't made any decisions on that. That can change. For example, if there's protection orders in place, then that presumption's kind of rebuffed. But on the whole, both parents are presumed to have equal rights to custody of the child. If the child's born during the marriage, then I'm just using heterosexual couples here for simplicity, but the dad is presumed to be the natural father of the child. If you were never married, then the court will look at a couple things for paternity. One, they'll look at is dad's name on the birth certificate? Did dad hold the child out as his own? If neither of those things have occurred, dad's saying it's not mine, then they might do a DNA or paternity test. Okay? And then, as I said, mom's no longer presumed for primary custody anymore. So, primary custody, I've been mentioning that word a lot. What does that mean? So, there's 3 types of custody with children, and there's sole, primary, and joint. And that refers to 2 different aspects. Physical custody, which we've been talking about, which is who physically has the child. And then another kind of more nebulous thought, which is legal custody. So what is legal custody? Legal custody is the ability to make major decisions impacting the child, such as schooling, religious upbringing, medical decisions. It's usually, like I said, the court's thought that joint custody, both legal and physical, is the best interest of the child unless proven otherwise. So that means both parents would work together jointly to decide where the kid's going to go to school, if they're going to be raised Jewish or Christian, for example, if the kid's going to have shots or what shots they're going to get, something like that. And then there's physical custody, which is a bit more straightforward when you think of custody. It's where's the child residing and who's the child living with. I just kind of gave a couple of examples there. Kid lives with mom one week and dad the next week. Or the child lives with mother but sees father from 9 to 5 on Sundays. That's physical custody. So now that we've kind of differentiated between those 2 items, we'll get into the sole, primary, and joint. So sole custody. Why would someone want this? Well, one parent would have sole physical custody of the child and could dictate what visitation, if any, other parent gets. One parent, and if it's applying to legal custody, then one parent would have total say over legal custody decisions, such as school and medical. And that also means that non-custodial parent doesn't have a right to get, for example, report cards or medical reports. It's all going to go to the parent with sole custody. The big thing on sole custody is that you can still receive child support. So, it's preferred for cases with severe domestic violence, although the courts generally don't think sole custody is in the best interest of the kid because they'd like the kid to have, time with both parents. But I know when I was doing domestic violence work, when people were like, well, I want to terminate his parental rights, again, sorry men, it was usually women I dealt with, but not to say I didn't have male clients. But they would say, I want to terminate his parental rights. And I talked to them about that. I'm like, well, it's actually pretty hard to terminate their parental rights. You need to show either like abandonment for 6 months to a year, really severe abuse, and I'm talking like abuse to the kid, like usually sexual abuse or extreme violence, or something else that, is more compelling. Courts really don't like to do that because they want there to be like money for the kid to do things. So that's where sole custody would kind of come into play, because then, again, I'm sorry, but I'm using mom. Mom would have sole custody of the child, so sole physical custody, could dictate when dad saw the kid, if at all. And usually coinciding with that sole legal custody, which means mom would also decide where a kid goes to school, religious upbringing, medical decisions. But mom could still get child support from dad. Okay? And again, it's usually not something the court prefers. It was something I saw come up a lot in cases of default, where one of the parents had filed for custody or divorce and the other parent, despite being served, just said, I'm not going to care, I'm not going to do anything. Well, then if I was asking for sole, then the court was like, okay, the other person doesn't care. There you go. Or again, extreme cases of domestic violence. That's the only times it comes up. Sometimes if there's a parent that moves around a whole lot, military for example, then sometimes they will grant sole custody for that purpose. But then if that's the case and there's no abuse or concerns, then they'll usually do a joint legal custody situation, so then other parent can at least be involved in the legal decisions even if they don't physically have the child as much. Primary custody. So, this refers to physical custody only. If you kind of think about it, no one gets primary legal custody of a child. That means one parent doesn't get to make primarily all the legal decisions about medical and health and religion. It's either all or you share it. So, it refers only to physical custody. And primary custody means the kid lives with one of the parents most of the time, but still has visitation with the non-custodial parent. So, example, father has primary custody of the child, but the child still sees the mother every other weekend from 5 o'clock on Friday to 5 o'clock on Sunday. That would be an example of primary physical custody. So joint custody, this is where we're going to spend a bulk of the time. Joint custody is what the courts generally like to do and what's generally presumed to be the best interest of the child. And again, I harp on that a lot and we'll get to that one. But again, NRS 125C, that kind of lays that all out. It says parents have joint custody until otherwise ordered by the court. So if you and your partner have a child and separate, the court is assuming that you have joint custody. So the other mom, for example, doesn't get to say, well, the kid's with me, I get to say when you get to see them or not. No. Unless there's some other compelling reason like protection orders or something else in place, it's considered to be joint, unless the court says otherwise. So, under the statute, the parent-child relationship extends equally to every child and to every parent, regardless of marital status of the parents. And if the court has not made a determination the custody of the child, each parent has joint legal and joint physical, like I was saying, until the court maybe orders otherwise. And I just want to be clear, a court can award joint legal custody, like I was saying, so that's the ability to make decisions on medical education, religious upbringing, without awarding joint physical custody. So someone can have primary physical custody of the child, but joint legal custody with the other parent. Does that make sense to everyone?
And what an example of when they would do that or why they would do that?
So, per example, maybe dad doesn't have the most stable living situation. He's, living with his parents who have like one bedroom and he's on the couch most of the time. Well, if mom has a 2-bedroom or the child has their own room, the court's probably going to say the child should be with mom then and not dad floating around on a couch. So they might award mom primary physical custody for that reason, at least until dad can get a more stable living situation. But if there's no other compelling reason why not, then they would award joint legal custody, meaning dad has equal right as mom to medical records, report cards, and to be involved in decisions involving schooling and those other major life events with the child. Does that make sense?
Yes.
Continued. So, joint custody, to be clear, doesn't mean 50-50. Okay? It can mean 60-40 under the statute, and there's been dicta in court cases where it can be even less than that. So why do you call it joint custody then? Well, tax reasons is the shortest answer on that. So where's something where you would see that come up? I saw that come up out in like the rurals where I would practice in Elko, where one of the parents worked for the mines. So on the mining schedule, like usually dad would work something like 9, 12 days in a row, and then would have a couple days in a row off. Well, it's kind of hard to do a joint custody situation with a work schedule like that, where it's equal 50-50. But we'd call it joint custody, and realistically, mom would have physical custody of the child more, which sometimes is what they wanted anyway. But for tax purposes, if you have joint physical custody of the child, you can alternate claiming the child for tax years. So if someone has sole or primary custody, physical custody of the child, they're going to be claiming the child for the dependent deduction every year. But if it's joint, then you get to switch off who claims the kid. You don't have to do that. That's usually what I would do in divorces to keep it fair if there was going to be a joint physical custody situation. Sometimes it can just be, dad makes more money, so let mom take the deduction every year. Or let dad claim the kid every year since he makes more money, and then he'll split that deduction with mom. You can find ways to work with that. Best interest of the child, thing I keep talking about. So, NRS 125C says that in any action for determining physical custody of a minor child, the sole consideration of the court is going to be the best interest of the child. And there's 12 factors they look to when determining what are the best interests. If it appears to the court that joint physical custody would be in the best interest of the child, then they will grant joint physical custody to the parties jointly. Kind of redundant there, but
That's a lot.
yeah, that's how they worded it. Preference isn't going to be given to either parent solely because one parent's the dad, one parent's the mom. In same-sex relationships where that comes up, preference isn't going to be given to one of the parties just because they're biological dad or mom. If they have agreed that that's the situation, the other parent's on the birth certificate, equal rights. Okay, so the factors. There's a lot of them. 12, in fact. I bolded the ones which I've kind of seen come up as more of an issue in my personal practice, but that's not to say that not all of them are important, because they all vary depending on the case and depending on the parties. So, A, factor, consider the wishes of the child, if the child is of sufficient age and capacity for making a preference to his or her physical custody. It's actually kind of a bigger one with a lot more stuff that's involved, so I have a slide devoted to that and we'll circle around to it later. Just know when they say of sufficient age, they mean 14. Any nomination of guardian for the child by a parent. That kind of comes up more in a guardianship situation. So, for example, had a case where, mom had an issue with drugs, dad was in jail. Mom knew that she wasn't really going to be capable of taking care of their 3-year-old, and so she nominated her mother, grandma, to take the child. And the court was cool with that. And if you're wondering, dad had nothing to say about the situation. He didn't bother saying anything. So, which parent is more likely to allow the child to have frequent associations in a continuing relationship with a non-custodial parent? Biggie. Usually before the court even gives you an answer on who's going to have what custody of the child, they're going to put some type of visitation in place before you have a final order. And they're going to look at how you handled that situation. So if, for example, dad has primary physical custody of the child, but mom's supposed to see them every other weekend, and dad is showing up late every single time with the kids, or calling mom last second to say, something came up, we can't do it. The court's going to look at that, and that doesn't look good for the parent that's not allowing the visitation to happen. Level of conflict between the parties. So this doesn't necessarily mean physical conflict or something that involves EV. It can be two people that just have come to hate each other. So if mom and dad literally can't be in the same room without yelling at each other, cursing at each other, being really stony silent, making it awkward for everyone, especially their child, no way they can work together to coordinate, pick up and drop off for an activity. The court's going to look at that too and see maybe who's the bigger offender on that. And that kind of goes hand in hand with E, the ability of the parents to cooperate to meet the needs of the child. If the parents are just squabbling nonstop and incapable of having any kind of adult conversation about, when are we going to pick the child up from preschool, or are you going to get the child dressed a certain way for photographs, something like that, the court's going to consider that too, and they'll probably look to see who's the greater offender on that level. So I always tell people, one, if you really know you're going to have animosity with your former partner, do it in writing. So text message. Or if you can do it, there's apps that you can get that are fairly cheap called Talking Parents, for example. I've used that one. And usually people, when they know they're being monitored and all that's being saved and can be pulled to show court, they tend to be a lot nicer to each other. So we're a lot more civil, at least.
It's called Talking Parents, you said?
Talking Parents. That's the one I've used. There's a couple other ones that are in play. that I know Washoe uses as well, and I don't know the names of them off the top of my head, but that's one of the biggies.
But can you get an order that they use that?
Yes, you can.
Okay.
You can specifically request the court. You can specifically request the court, either yourself or through an attorney, that there's difficulties in communication and that you would like both parties to be using, if it's stalking parents, that. And usually the court's down with that. It's not very expensive unless there's a party that says, I can't afford that, it's $100 a month, which some of them are pricey. Then usually the court's on board with that, especially if there's especially if it's clear that there's a history of animosity there.
My daughter's got email, but I did the email only. But you can still manipulate email. So
You can. And that's why talking parents, it's saved whatever you put in there on kind of like a cloud situation. And you can pull that and show the court exactly what was said. And I had a case where they were using that and the dad was being kind of a jerk, to put it mildly. And he lost his week in visitation because he couldn't handle himself civilly in conversations with my client.
Yeah,
And
it shows a spot
he
on there
improved.
where it says seen in red and it has all
Yeah,
red
and it has dates it was sent and all that, so if you're trying to claim I never saw that, it will be like, well, no, yes, you did.
Yeah.
So that's a good one if there's difficulty in communication. Writing, but the courts really like you to use one of the court things. So if you specifically ask, again, talking parents is one I'm familiar with, but I know there's others out there for varying price ranges that are more strict than text messages or emails, which could be altered or deleted. Okay. So the mental and physical health of the parents. I didn't really bold that, even though I've had it come up. I've had it come up in situations where maybe one of the parents had a past drug issue or they had bipolar disorder or something like that. So obviously if there's like drugs or anything with mental health concerns, the court's going to want to know if that parent is actively seeking help for that or on anything for that. And if the answer is no, they're on nothing, but they're not necessarily denying there might be an issue, then you better believe the court's probably going to order that therapy or something happen. Physical health, I really haven't had that come up. I had it come up once. My client had cancer, and dad was trying to say, well, because of the cancer, she's way too weak to handle the kids and blah, 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 blah. Well, the kids were teenagers, so that really didn't fly. But if you think about it, if it's like a little kid that needs to be picked up and carried a lot, if the parent's way too weak to do that or other things, that could be a consideration. But the court's not necessarily going to make some ableist decision and say, well, dad's in a wheelchair, so, that's out. They're not going to do that. But it can come up. It can be raised. Some more factors. Physical, developmental, and emotional needs of the child. So I like to kind of think about this. If you have a child, let's say, with autism, they're going to be a little more needy. They're going to need special attention, probably special services. If mom's just like not responding well to that and gets frustrated and yells at the child a lot or just like ignores the child, the court's going to look at that, for example. Is the child's needs being met with that parent? And dad could argue in that case, no, they're not. So the nature of the relationship with the child with each parent. So kind of think of the situation where maybe dad's a little more absentee, so the child's closer with mom, and they don't have the best relationship with dad. In a situation where that's going to be a feature that's highlighted, the court might order for visitation prior even to making a final custody decision that maybe visitation with dad is staggered to get the child used to being, especially if they're young, get the child used to being around dad again. So if dad has kind of been out of the picture for whatever reason, they're not going to just say, oh, okay, week on with dad, week on with mom. They're going to say, well, dad, you need to kind of build up to that first, because the child might not know you as well. So the ability of the child to maintain a relationship with any sibling. So this is kind of like a step-sibling situation. So if dad has a daughter from a previous relationship, and daughter and child with partner who he's now having an argument over custody with are very close, the court's going to look at that. Because the court's going to want the child to have a relationship with their step-sibling, especially if they're close. That doesn't mean just because there's a step-sibling that you've got to one-up on someone who doesn't, to make that clear. It's just something that you could use to help your case. So any history of parental abuse, neglect of the child or the sibling of a child. That's going to kind of go hand in hand with subject K, which I'll get into in a second. And that's a lot of where I lived when I did law in the family law section. So if there's if there's kind of a conviction out there for child neglect, well, one, you better believe the other parent's going to bring that up toot sweet. And that's something the court's going to consider. Like, what were the allegations there? If there's an actual conviction, how long ago was that? What steps were taken? Was anger management classes, parenting classes taken? Doesn't automatically mean that parents forfeited a right to joint custody, but it means they're going to have to work hard to prove that they overcame whatever that was. So K, the one I've harped on a bit. So, whether either parent or other person seeking physical custody has engaged in an act of domestic violence against the child, a parent of the child, or any other person residing with the child. So an older sibling or a grandparent if they live together, for an example. So there's a rebuttable presumption that if you can prove by testimony, reports, convictions, what have you, that there was domestic violence, that primary or joint physical custody with the abuser is not in the child's best interest. So, for example, when I had clients come to me and they're like, I've had terrible relationship with my ex, and again, I'm not trying to pick on the men, but it was usually women I had, but he beat me. I've had to have protection orders against him in the past, and the last time he slapped me in front of our 5-year-old. So in that kind of a situation, I would definitely be raising subject K immediately, because one, I'd want to get a protection order in place first, because that's already going to dictate what kind of temporary visitation happens before a final order. And then if we had to do a temporary custody hearing, which is going to determine the type of custody you have prior to a final decision, you bet I'd be raising that, and you'd probably have to bring in police, or if there's other witnesses to any of these things who are over 18 years or older, I'd be bringing them in to say what they saw, what happened. And 9 times out of 10, if you could prove that, you weren't the person who had committed the assault was not going to get what they wanted out of that. They weren't going to get primary or joint. Certainly weren't going to get sole. And you were able to put a lot of conditions on visitation. So, for example, they could have visitation for only 4 hours, and grandma or some other trusted third party had to be there, and it had to be in a public location, that kind of thing. And then I kind of skipped over it, but L, whether either parent or other person seeking physical custody has committed an act of abduction against the child or any other child. So I did have that come up, and it's not necessarily I took the child and there was an Amber Alert. It was a situation where my client and her partner had separated. They had twins. And the dad just decided that mom couldn't handle it for whatever reason, so he just took the twins with him to Reno. They lived in Felon. And so he just took the kids with him to Reno and then wasn't allowing her to see the kids or talk to the kids because he was, quote, busy. That's abduction under the law, I'm sorry. So we had to file for an emergency custody hearing, and when the judge kind of heard all that, he immediately took the kids away from the guy and gave them to the woman full time. And the guy got a pretty strict reprimand on why he wasn't supposed to do that. For the record, that case actually ended up amicably, and they have joint custody of the children now. Okay, so I come back to this. Do children get a say in physical custody? So generally, the kid has to be 14 years or older, and then they can say, I'd prefer to live with mom or dad. But it's been my experience that there's a lot of issues with that, and there's a lot of law involving that. It used to be that the judge would just kind of take the kid back into chambers with them and kind of have a discussion with the child about maybe who they'd like to live with, and neither parent got to hear, which I kind of thought was good, because the kid doesn't really want to hurt either parent's feelings usually. But then a lot of stuff was kind of coming up, like, well, the kid's just being manipulative, or, whatever the situation is, mom or dad coached the kid to say X and Y. So more recently, right before I kind of stopped doing the practice of law, what was happening was the kid would get up, mom and dad would leave the courtroom, and if there's attorneys, the attorneys would both be present. And then the judge would ask the child questions on the stand. And then there was a lot of nonsense about whether or not the parents could see what the child said and blah, 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 blah. It's real messy. And so I would tell parents, unless your child really feels strongly about this or there's some real good reason, please don't put them through that. Like, don't bring your kid to court, really. Okay? So, another fun one, child support. So this is under 125B. And I didn't really want to go into that because it's a hot topic, but I have to. So, child support, how is it calculated in Nevada? So under NRS 125B.070, obligation for support means the sum certain dollar amount determined according to the following schedule, based off the parent's gross monthly income for all sources. So it's based off how many children. So for example, one child is 18% of your gross income from all sources, 2 children is 25, and so on and so forth. Had a guy with 6 children, he was paying a lot. But that being said, before everyone freaks out, it doesn't mean entirely like a solid 35%. There's caps, which we'll get to. So there's presumptive maximums on child support. These are based on one child, by the way. So They're going to look at what the income of the non-custodial or the payer or parent makes. They're not going to pay the extra $84, she's capped at $500. And again, this is per child though. So if there's 2 children, then it's going to be $1,000, okay? What do you do in a joint custody situation? Because that's all for primary or sole, where the parents have joint shared custody of the child and you would assume are doing joint financial responsibilities for the child. Well, there's a formula for that, and it's pretty easy subtraction. So for this example, dad makes $4,000, mom makes $3,000, and they have 1 kid. So we don't do the caps, by the way, when there's going to be joint. So it's a straight 18%. So 18% for dad is $720, 18% for mom is $540. You subtract $540 from $720 and get dad's child support. Okay? Sometimes if the parents make pretty equal pay, they can stipulate to not do child support, but it has to be pretty close. So, you know, if it's a difference of maybe dad makes $150 more than mom, you know, the court might say, you know, it's close enough, and if mom agrees, we're not gonna order child support. But it has to be close. Both parties have to agree. So more child support fun. So regardless of income, the presumptive minimum amount of child support a non-custodial parent has to pay is $100 per month per child. And that applies even if the obligor parent is out of work or not working. So I've had cases where, you know, dad was just like, oh, I don't work. Well, maybe he worked under the table. So the court was like, okay, well, you still have $100 a month for your kid. And, you know, that adds up. If he's not paying it, you still collect arrears and everything on that. A situation where a trickier situation is where one of the parents is in jail. So let's say you file for divorce during jail and you want child support. Some judges will just go ahead and do that. And dad will start accruing, men will start hypothetically accruing $100 a month in arrears for while he's incarcerated. Most judges now are just kind of like, that's not very fair. So they'll say that he has to start paying child support as soon as he's released. And usually he doesn't have a job initially lined up, so the first month would be $100. Does that make sense? Okay. So the court can deviate from that child support schedule I was showing you and order either less or more after they have a hearing and special findings are made. So i.e. if your child has special needs like severe disability, if one parent earns significantly more money, they might be paying a lot more money for that. Or where I typically saw it come up, the cost of health insurance. So if the parents are both working, but dad's job provides really good health insurance, but he has to pay out of pocket like $150 from his paycheck for that, that'll be deducted from whatever his child support obligation would have been. Okay. So another thing to remember is that Social Security can be garnished for child support, and that includes Social Security disability. It's one of the very few things that can touch that is child support. The district attorney's office are generally who's in charge of collecting the child support if one parent just isn't paying. I mean, ideally you'd like to think that whoever's supposed to be paying is putting the check in the mail or whatever it is. I mean, if that doesn't happen, then you go to the district attorney's office, show them your order for child support, and they will go ahead and they will enforce that. And the person who's not paying can get hauled into court. They will be fined and sanctioned on top of what they owe. And fun fact, child support literally never goes away. When I was in private practice, actually, we had a case where the guy and the woman had been separated for 40 years. He'd stopped paying child support at some point along the way when the kids were still young. Nothing was ever said until I guess she saw him at the Peppermill Casino and decided he looked like he was doing good for himself. And so she brought an action against him for child support arrears, and he owed a lot, to put it mildly. And now his Social Security is getting garnished, because you don't get out of that order. All right. So, parent-crafted custody agreements. These are the best kind of custody as far as the court's concerned. If you and your partner, whether you were married or never married, can come to some type of an agreement on custody for your child, in the court's view, you know what's best for your child, and that's better than anything they'll come up with in a contested trial. You can be more creative and free than a court-designed custody plan in terms of maybe like what hours are happening, where the child's being picked up from, or what's happening. It's generally preferred by all courts. And my experience was the courts will pretty much always grant whatever mediated or agreed upon custody plan you come up with unless it violates a rule or the law. So for example, if one of the parents is making a lot more money than the other and they're like, no, we're not going to do child support, that's probably not going to fly. The court will say, we approve this plan, but you know, you're paying child support. Okay, so resources in Washoe County. to help people through all this stuff. Obviously, the Second Judicial District Court, when you're doing divorce or child custody, it's always going to be the district court you go to, not the justice court, district court. It's located there on Court Street. I would highly recommend, if that's something you're looking into with custody or divorce, that you go to their website, washoecourts.com. You go down to forms and packets, and then you go to family-related forms, and that has literally everything we've just covered for filing for initial custody to anything more complicated. They do lawyer in the library, specifically a family law session on Tuesdays at 4:25 p.m. It's kind of a first come, first serve, 20 minutes with an attorney. And then Washoe Legal Services, my organization at our main office in Arlington, has a forms clinic. So that doesn't mean you get an attorney, but some of these forms that you'll get online or at the court are a little hard to understand, and someone can go over them with you and make sure you fill them out correctly. All right, questions? I tried to save as much time as I could for that.
So I know we talked a lot about, like parents and stuff like that, and custody and stuff like that. What do grandparents and child's been with grandparents since basically birth, and how does all that? Totally different, obviously, right?
Right. Well, I mean, one, why was the child with the grandparents at birth? And was there an actual court order giving the grandparent a guardianship over the child? Because if the child's been with grandma since birth because both parents were in jail or have a drug issue and there's an actual court order saying grandma has, grandma's the guardian of this child, then yeah, parents are going to have to go to court at some point if grandma's not willing to voluntarily give them back and prove that they've corrected whatever the problem was that got the kid with grandma in the first place. So usually in those situations, though, the grandparent's more than willing to let the parents back in if they've righted their wrongs, and they can just collectively go to court and agree that guardianship is no longer appropriate and the kid can go back to the parents. Okay.
I have a question for that.
Sure.
Let's say, the parents are separated, but, for some reason the parents or the mother and the father don't want the grandparent involved. Can a grandparent as well go in and go through the court to be able to see the child?
There are not grandparents' rights in Nevada. I guess, let me rephrase that. So there really aren't grandparent rights because for every great grandma and grandpa in the world, there's a crappy one, let's be real. And parents have the right to say, I don't want you involved with my child, you screwed up my childhood, I don't want you screwing up this kid. In situations where, for example, let's just say the dad is deceased and mom wants nothing to do with his side of the family, but the grandparents would like to see the kid. If mom has allowed literally no communication, and that's just grandma and grandpa aren't happy with the amount they've had, none, zero, zip, zilch, then they can maybe petition the court for some type of visitation, maybe. But again, dad needs to be, completely out of the picture or something like that, because otherwise, the thought is, well, if, dad's gonna have the kid, why doesn't he let the grandparents see them? And if dad's saying, I don't want you to be around them either, then they don't really have a leg to stand on. Okay. I know something I didn't really touch upon was move away. And that's what if, there's a custody decision in Reno, and let's say it's, mom is primary custody, but dad sees the kid every other weekend. But mom decides she's going to move to Idaho, and she has a fiance, and, that's what she's going to go do, is go get married and live in Idaho now. What's dad's recourse to that? We'll assume dad's not tight with that. So in those kind of situations, there'd be a move away hearing if the parents can't agree. And to be clear, the court can't stop you from leaving or doing what you want, but they can stop the child from leaving. Okay? And so in cases where there's primary or sole custody, it's easier if that's the parent that's seeking to move. It's easier for that parent usually to get it, but usually there's going to have to be some accommodation made. So if it was a situation where maybe the kid's, let's say, 10, and dad was seeing the kid every other weekend, and mom says, well, I'm moving to Idaho, and dad says, well, what the heck, no, because then I can't see the kid every other weekend. They'll have a hearing, and the court might well grant mom to move to Idaho since she has primary custody, but then dad might get the kid for the entire summer. So something like that. It's trickier if it's joint custody. So if both parents have joint custody and one parent wants to move with the child out of state, then it's a lot more tricky because you're going to have to kind of prove, essentially almost like you would for the home state thing, what's the great appeal to taking the kid to this other state as opposed to where they are now. Because they're already going to come out on the footing, well, you're taking them away from a parent who's staying, so that's kind of crappy. So what's the draw? Is, let's just say dad wants to move away with the kid to Texas. Is dad gonna be making a lot more money at this new job that he has? Is the kid gonna be in a way better school system? Are there gonna be way more activities for kids that aren't available in Nevada? Is there additional family support out in Texas that isn't in Nevada? Like grandparents, cousins, all of that stuff. You have to really build your case for why the new state you're trying to take kid from is the better place for kid to be and worth essentially taking away that relationship that they had with mom. And again, if the court grants that, it comes with a cost. So if you're not doing week on, week off, mom's probably gonna get this entire summer and probably gonna get most major holidays, for example. Something like that. Or if mom happens to be in Texas and you have plenty of notice, you better make those kids available. Something like that. Right? Again, I didn't really do a slide on that because in cases where I did a lot of domestic violence cases, and in those situations, usually it was people who had sole custody or primary and they were trying to move away. And I usually just would motion the court and say, dad didn't bother to even show up to this, so court, can we just move away? Because you do need a court order to move. And the court was usually like, yeah, fine. He didn't bother to do anything, we defaulted on this, go for it. So
Elena, people, if the father wants to see the child but's not paying child support, can a mother say, no, you're not allowed to see them?
no.
Okay.
You can't penalize people for essentially being poor. Even if he's not and he's just being a jerk, then that's on the DA to go after him for. But the thought is, you don't get to ransom the child. Because sometimes things just do happen. So
what form is it that you fill out if they move out of state?
So it's not a form, you need a court order.
So like I'm talking to her, it's my ex-wife, she asked if she could move out of state, she moved to Boston.
Okay.
So,
Well, I'm gonna assume you agreed to that,
no, I said absolutely not.
and she did it anyway?
Yeah.
Well, then that's kidnapping.
Yeah, and I called the cops and they said nothing. They said they go check the last known address and that's it.
So you need to file something with the court and basically say, this was our custody arrangement, she's kidnapped the children and moved to Boston.
Okay.
She can be in big trouble for that,
Good.
if that's what happened. You
Yeah.
can get the children back. It'll be a trial.
Okay, that's
So.
good to know. Thank you.
As far as change of income,
Mhm.
and you're the one paying child support, how long does it take to or do they adjust it? To say you are getting paid less now, or
So don't assume that they'll know that you're being paid less. It's always on you to let them know what your financial
Yeah.
situation is. So if you've had kind of a career shift and you're not making less than you were, you can go and file for a change of circumstances and basically just show proof that, you're not earning what you were before, you're earning less than that, and you'd like your child support to reflect that. Sometimes they'll make you do a hearing on that.
so it could take some time.
It could. If the other person's not going to deny that you've got a new job and you're making less money, then that is what it is. They'll just be mad about it.
Yeah.
Another question.
Sure.
So I pay my full child support, but then I'm recently having another baby. Does that offset or do I, or?
Does not offset.
You still pay, okay. Fine.
No, it's fine. No, it's a good question. But from the court's point of view, your obligation to your other two children, let's say, doesn't change just because you've decided to now have another child. You
Yeah.
still owe them the same amount as you
Exactly.
would.
That's cool.
So, yeah. Any other questions? All right. Other than that, I'm going to call it a go then. Thank y'all for coming.
Thank you.
Thank you.
If everyone could just take a moment to answer the after the presentation questions for me, that would be great. Thank you all for coming. If you have any follow-up questions, you can contact me. I'll leave my business card up